Hi, this is Joe Esquivel with Mortgage Compliance Investigators. Today's topic is based on an article that I've written, The Two Faces of Quiet Title. What is quiet title? I asked this question to get the reader to think about the two faces of quiet title. First, quiet title is an equitable cause of action that many homeowners use to identify who may have an enforceable, equitable claim to their title. The reason that many homeowners file a lawsuit for a quiet title as a cause of action is because they believe that there is a cloud on the title to their property and that this action would quiet any challenges or claims to title. In this modern world where MERS was utilized, there are in fact two possibilities of who holds title, legal and equitable. Whereas with many security instruments, legal title will, upon agreement, be written with the security contract, be granted to a trustee. Legal title in title theory states, and the right to sell title in lien theory states. Such legal title does not interfere with the homeowner's equitable title, so far as there is not a default of an enforceable security instrument, which is the enforceable right to legal title, which is the question. It may be possible that under the security side of the two-part contract, that enforceability of the security instrument has become a nullity. Thusly, all rights to title, legal and equitable, would fall back to the equitable title holder's name. Whereas an agent for MERS operates as an agent for a party that has enforceable rights to the promissory note and can be lawfully identified, then equitable title would be a junior claim to a superior claim to legal title. However, when the superior party loses rights to enforce the promissory note by loss of agency relationship, all rights to title, legal and equitable, fall back to the equitable title holder's name. For a party that has not a perfected and legal right to title, to attempt to claim superior rights to title to a prudent-minded person is clearly an attempt to steal real property. Whereas quiet title as an equitable action, one must be assured prior to filing an equitable action that no lawful legal actions are available. Second, quiet title is also an equitable remedy. It is a remedy which removes the cloud or possible encumbrance on the title of real property. The problem is that in order for the homeowner to receive quiet title as relief, the homeowner must meet their state statutory requirements of law for this action. Most states require in order for quiet title to be granted as equitable relief that there cannot be an enforceable equitable claim to title to their property evidenced by an obligation such as a properly secured mortgage loan security instrument. Many homeowners filing this action do not truly understand the true faces of quiet title as a cause of action and as an equitable remedy. What happens many times is that unfortunately the quiet title complaint is remanded to federal court based on diversity in the monetary threshold of $75,000. Once this case was remanded to federal court, the defendants then file a motion to dismiss based on the 12b-6 rule, failure to state a claim for which relief can be granted. The Rule 12b-6 is designed to screen out cases where a complaint states a claim based on a wrong for which there is clearly no remedy, or a claim on which the plaintiff is without the right or power to assert and for which no relief can be granted. When the homeowner files a quiet title action and there is an enforceable, equitable claim to title other than theirs, there is no remedy. Relief will not be granted. One must be careful as to not to put the cart in front of the horse. All actions must be timely, and quiet title as a cause of action should not be done as you come out of the gate. The action that this writer would look at first would be a determination of the status quo for all interested parties claiming an enforceable, equitable interest to real property. A declaratory judgment would move the courts to address a controversy such as a cloud on title by identifying if rights have been properly acquired in accordance with law. So quiet title is a cause of action and quiet title is a equitable relief are two separate faces. Thank you.